will be realized. Right. Good morning. It is May 20th. We have Ben from Ledge Council here to talk about an amendment. Just for some brief background, these were some proposals, I believe. All of them came from Judge Donay.
Pretty much, yeah.
Okay. Yeah, a few amendments that were brought up at Ledge Council shortly after we voted the bill out. I believe they're all technical in nature, but we're just going to get a quick walkthrough just to make sure we're all good.
Well, I can't. I'm just waiting on a link, but I'll just start. It should be sent to you. Internet, and there we go. So for the record, Ben Novogroski from the Office of Legislative Counsel. Before the committee is a proposed floor amendment that apparently I was on inadvertently. It's I will H105. I will resend that to Will. So that's the one that's voted on.
What did you?
H105 in the top, I guess, of inadvertently pressed. Does it say I will on yours?
No.
Oh, good. Okay, so that's your mark. Never mind. Strike that from the record. So for the record, it is H105, a floor amendment. And as Chair Sheem alluded to, most of these come from Judge Donay kind of in the 11th hour doing a review and realizing that there were some things that needed to be cleaned up. So the first instance of amendment is just a miscite to highway. So it would now read in the definition section, subsection A, for that it would be 23 VSA 1207. That's the definition of highway that excludes a driveway from the meaning, and that was consistent with how this was handled in Title 23, because there are two definitions of highway in Title 23, and your esteemed legislative council selected the one that wasn't specifically designed for this statute. So,
And just briefly, can you explain why driveways are being excluded from this?
it must have been a policy reason from before my time, where I suppose if you are in your driveway, you cannot be prosecuted or cited for a violation under this section. So that's the operative effect, is that if you are in your driveway, you cannot be cited for a civil violation.
Unless you, and so just to make it clear, it's, as I understand it, historically, somebody can, in theory, drink in their house, go sit in their car in their own driveway and not be prosecuted. But if somebody is driving down the road, public highway, being followed by the police,
Yeah, they were.
and then they pull into their driveway, they can still be prosecuted.
Yes, that's my understanding as well. And I'm just going to read for you the definition really quick. So highway has the same meaning as in the other cross-reference, except that for purposes of this subchapter, highway does not include the driveway that serves only a single family or two family residence of the operator. The exception shall not apply if a person causes a death of a person, causes bodily injury to a person, or causes damage to the personal property of another person while operating a motor vehicle on a driveway in violation of section 1201 of this chapter. So I think that hints at, and if they're, I think in the example that you gave, they are witnessed driving, off of their highway. That's enough evidentiarily to, I think, at least make the allegation. Yeah. So moving on to the second instance of amendment. So this, in the underlying bill, the way it would read is, someone can be cited and shall be suspended. It does not, or shall serve a suspension of. So this is that automatic suspension that goes into effect if you are cited for a violation under this chapter. And after talking to, and this is kind of conjoined with the third and fourth instances of amendment, who the person actually taking the action of suspension is. This is clarifying that's Commissioner of Motor Vehicles. There's some questions, law enforcement officer making a decision, or who is doing that, because as you'll see, there's a process now to contest or at least review the automatic suspension, and this clarifies who the proper official would be to bring that review against. Does that make sense? The third instance of amendment is related to, so essentially just replacing subdivision T1, really just to include on the top of page 2 here, the new subdivision F, which on the notice of suspension, there's a series of informational points that are included. And this would now include the ability to review the imposition of the automatic suspension pursuant to Rule 75 of the Vermont Rules of Civil Procedure. And you'll see in the fourth instance of amendment, it's adding review of the automatic suspension under Rule 75. One point that Judge Zone brought to my attention was, well, what if somebody is cited and there's a questionable reason underlying the citation? You know, somebody was profiled perhaps, and there wasn't really enough evidence to support the citation. Does the person just have to endure the automatic suspension? And so what this is doing is adding a new subdivision B to 656 subsection H to establish that prior to filing of the complaint with the Judicial Bureau, a person who's aggrieved by suspension imposed, the automatic suspension, may seek review of that imposition pursuant to Rule 75 of the Vermont Rules of Civil Procedure. This is already in place to review the decision of the diversion program if they, for instance, require further counseling of the subject. So the process that's already exists in the statute, and we're just essentially expanding it out. And that's why you're including the Commissioner of Motor Vehicles as the person who's named, the person that imposes suspension, and then this process to review that decision to actually suspend. And then again, the information included on the notice of suspension so that the person is aware of that option.
So just to clarify, the only new language in the third instance of amendment is what's on lines 3 and 4.
Correct.
And that coincides with lines 11 and 14.
Correct.
Okay.
So 11 and 14 are essentially the substantive right, you will, for lack of a better term, or to contest or review the automatic suspension. The third instance of amendment just is the mandate that the ability to review it is included in the notice of suspension that the person receives roadside.
All right. So 3 and 4 creates the ability to contest it, and then 11 through 14 is the substance of how it goes. So,
Right. So for 11 through 14 gives you the ability to review it. So that's the operative provision. And then 3 and 4 just includes that information on the notice of suspension that you received. And then the second instance of amendment just clarifies who you could seek review of, which would be the Commissioner of Motor Vehicles.
So there's still an automatic suspension, but it's just that you have the opportunity to have it viewed. There could be errors, there could be major issues. So that's in line with how we have other suspension procedure for DUI.
No, it is a different procedure as far as for for instance, in a standard DUI procedure, right? You get the criminal charge and then you also get the civil suspension under 23 VSA 1205. That civil suspension procedure is its own procedure that essentially proceeds parallel with the criminal proceeding. You can ask to marry those timelines. You can dispose of the civil first. Remember, this is different than that. But this is an established procedure we have under the rules of civil procedure. It's already incorporated in this in the statute to seek review of the diversion program's decision and to seek further counseling. So it's not unprecedented. It's included, but it is different than the civil suspension procedure we have for, I guess, just standard DUIs, if you will.
Thank you.
And that's where I was confused that H105 is dealing with use, substance abuse. And I was concerned about, so we're changing what's referred to 240 form in its entirety going through this, but That's a different procedure as far as the DOI is concerned for individuals.
Correct.
It's a civil suspension, I think on the first Wednesday, 14 to 21 days, Wednesday falls in there.
Right.
Okay.
Yeah. And this also doesn't preclude a criminal prosecution. There's that on top of it, but this is, to keep it in this world is more of a rehabilitative, regime, if you will. But there's still the criminal aspect that could be charged if the facts warrant it.
So I'm looking at the last paragraph on page 2. And it says, prior to the filing of the complaint with the Judicial Bureau, is the person aggrieved filing the complaint, or is the state filing the complaint?
So the complaint would be filed by the state. So the way that this works out, in this is that the person has to enroll in the YSATS program. But if they don't complete it, or if they don't enroll, the complaint is filed with Judicial Bureau, and that kicks off sort of the adjudicative portion of this. So that's how it works. The incentive is sort of that withholding of the filing of the summons by the diversion program and by the law enforcement officer.
Okay, so I'm sorry.
And so what this does then is that this is a different process. So prior to doing that, if they want to review the initial automatic suspension, which is automatic essentially, they have this process to file in civil court.
When you say they,
The person.
Yeah.
Who's agreed by the decision. So
Okay.
the subject.
so you have a right to challenge the suspension
Correct.
before it's filed, before the authorities file with the judicial.
Right. And because there's that secondary sort of, if you fail or don't enroll and it goes to the Judicial Bureau, you can get those enhanced suspension timelines. So this is just for that initial, for your first offense, 90-day suspension. And so if you enroll in YSAT, you do everything else, but you don't think that your license should have been suspended at the outset, you can file a petition with the civil court, to see that through.
Okay.
To be candid, probably a little bit of a clunky procedure, but just given sort of the time frame and timeline, this is what Judge None and I had sort of triaged, if you will. And this is something that if you want it to look more like the civil suspension procedure under 1205, this could be revisited next year and you could build out a procedure like that.
Thank you. Any other questions? We good with these changes?
I'm good.
What? Okay. On Senator Matos. And could you call the roll?
I do have just one question. I do know, Senator Sheen, we had discussed briefly if other members wanted to join on the amendment to show support or not.
Sure.
But that's,
Yeah.
I think
Oh, yeah,
it's a discussion. I just wanted to bring it up as a policy decision.
Could make it a committee amendment, but Matos isn't here, so. Does everyone else want to sign on to it? Well, actually, no, then it'll be weird if everybody but Matos is signed on to it. So
I think you might be overthinking it.
let's just leave it as it is, and I'll just, it's fine.
That's for Rich.
Yeah, no,
Yeah.
okay. Thanks for. All right, we're good to go.
Senator Norton.
Yes.
Senator Hofsky.
Yes.
Senator Bruce.
Yes.
Senator Matos. Absent. Senator Machine.
Yes.
Okay, that is 401 in favor.
Thank you. I'll bring up a clean copy today. Work this out tomorrow. It's like on the floor today. I think that concludes the orders of the day.